Assalamualaikum and a very good morning. Architect Abu Zarim, PAM Deputy President and also the Chairman of CPD Committee, PAM Council members, PAM members, PAM CPD Committee members, Secretariat staff, and also Garis Pizza, who is providing the technical support for this CPD online program. Welcome to this virtual session of PAM CPD Unlimited. 2 years ago, in November 2019, we had our first CPD Unlimited for the first time. I was invited by Architect Wan Sofia, the coordinator for the CPD Unlimited 2019 program, to present a paper. Regret that I have to decline the invitation because it clashes with my another program, the 9th Annual Development Conference in Singapore, where I was invited to present a paper together with our Minister of Housing and Local Government, YB Zuraida Kamarudin. I was informed by Architect Wan Sofia that the session in KL was well attended and there were minor issues on car parking space and room availability when we did the physical session 2 years ago. Time allocated for speakers were too short. Some couldn't finish the session before the following session starts in the same room. So initially, Architect Abu Zarim, the CPD chairman, planned to have physical CPD Unlimited program on 15 December last year. But due to the pandemic, then we have to postpone to 9th of January 2021. But again, the MCO was also extended several times, affecting our schedule. Finally, we have decided to have this session online. So today, this session will be conducted fully online due to COVID-19 pandemic and the SOP that we have to comply with. I hope this virtual session eliminates the problem that we had before. No more car parking problem, no more room availability problem. But please be prepared and tolerate with us. With this virtual session, speakers are everywhere. They are at home, in their office, and some are at PAM Center. So we are running multiple sessions concurrently. It is stretching the internet bandwidth that we have. But we have our technical team on standby. So we are experimenting this virtual CPD Unlimited for the first time. There are many things that we will learn from this session. Speaking on learning, I hope participants will learn new things from this program today. Under this pandemic and economic challenges, it is like racing. Every day we have to learn and get the new knowledge. Otherwise, we'll be left behind. We are happy to have our speakers willing to share their knowledge and new technologies with us today. I am glad that we have Architect Razin Mahmud. He will be sharing his journey, small team with big dream. And we also have Dato Architect Saiful Anwar Aziz. He will be sharing his experience as a sole proprietor exporting services overseas. And of course, our special guest, Dato Sri Engineer Zaini Ujang from Ministry of Environment and Water. He will be talking about eco-shift in built environment. We also have Taufik Nazaruddin Nohayati Ahmad speaking about digital solution and Internet of Things. We also have Associate Professor Dr. Ahmad Tamizi from UMP Holding. He'll be speaking on BIM organization transformation. And we have Architect Gary Wong also talking about BIM today. And other than that, we have many more speakers on various topics. On fire safety design, we have Architect Chong Lee Seong, Engineer Hao Jiang Te. On construction contract-related subjects, we have Architect Joseph Tan, Architect Lu Chi Kiong. We also have David Yek. We'll be talking about mediation and dispute resolution. We also have the topics on conservation by Mariana Issa, Mangjit Kaul, architect Rida Razak and Ahmad Najib Arifin, and also on urban design by Associate Professor Dr. Sharifah Salwa. I will not be able to say to mention all the names, but there are many more speakers. You can check with the program. And later in my session, I will also share the finding from our survey from the government agencies, developers, contractors, and individual project owners on what do they expect from architects in providing architecture services. Recently, we have conducted a survey to get the feedback from developers, contractors, and also government agency on their expectation on architects' services. And on behalf of PAM, I would like to thank each and every one of you for being here virtually today. This is our first ever virtual CPD Unlimited program. Please give us feedback at the end of the session so that we will improve things in the future. I hope that all participants will enjoy this session and have a good interaction with the speakers. Make sure you interact with the speaker. Don't just leave your computer on, but you are not there. So enjoy the session. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Thank you.
Moderator, you may speak now. Moderator, you may start now.
Yes, thank you. Would like to request the host to allow me to video. Thank you.
Moderator.
Thank you so much. All right. Thank you. First, thank you to our president, Dr. Architect Izumi, for his opening remarks. And hello and very good morning to all of you. Welcome to PAM CPD Unlimited 2 for year 2021, a webinar series, the first ever digital CPDs that we run through for this year. So this is the event involving the collaborations. For this particular session is for two committees. They are actually from the Alternative Dispute Resolutions ADR committees as well as the CPD committees. So let me introduce myself. My name is Architect Alice Leong, a practicing professional architect and as well as the professional interior designer. So I am also a qualified GBF facilitator as well as a co-chair for the Housing Urban Wellbeing Committee as well as the GE committees. So without further ado, thank you so much for sparing your precious time to be with us in this wonderful, beautiful Saturday's morning. So ladies and gentlemen, this PAM CPD Unlimited series, like what our president has said, it was started in year 2019. That was first one, and that was conducted in through the physical without before the pandemics. But in this year, we do it differently. But I totally agree with our presidents. It's more flexible, and we can do many sessions in various different virtual platforms by all the speakers as well as the moderator. So each of the sessions, we will bring together the collaboration from all the industries with renowned architectures and other construction industry professionals to share their experiences from various capacities and the perspective, including the industry, businesses, educations, dispute, to address current key issues and the challenges. So hence this year, I would like to thank you so much to our CPD chairmen, also currently also the PAM Deputy President, Architect Abu Zarim, has again making very good effort to to start this and continue this CPD Unlimited series. So before we start these sessions, I would like to really announce two very important announcements to all the participants. So please take note, these sessions is actually CPD's points applicable. So to claim your point, you will see actually a QR code provided to you. There are two QR code provided on the screens. So, but it will in different sequence. The first one you'll see on the screen. So you must actually scan, and that is your check-in. So the other one will be provided at the end of the sessions, and you must scan it again to check it out. So that will actually make you eligible to claim for the points. Otherwise, if you scan the first code or the last code, you will not get your point. So you must make sure you scan twice for two different codes at the beginning and also at the end of each of the sessions that you are logged in and logged out. So without further ado, another one, you may raise your questions. You will see a Q&A box at the bottom of the screen. So please drop all your questions there. We will pick it up later at the Q&A sessions later. So with that, I would like to welcome our PAM-ADL co-chair, Architect Daniel Chu, to give his very short welcome remarks. So Daniel, hand it to you.
Okay, thank you, Architect Alice Leong. Okay, I will do a very quick one because I don't want to take up the time for our speakers. So let me introduce briefly on myself. I'm Architect Daniel Chu, a practicing architect, and then one of the current 2020 and 2021 council member. I'm also the ADR co-chair, MAP co-chair, and also the membership and youth committee co-chair. Okay, PAM Alternative Dispute Resolution Committee, or we all known as the PAM ADR Committee, is formed with a mission to promote the enhancement of our professional services, particularly in the building and also the construction industry. And also we want to expand the capacity building to be competitive locally and also globally. Okay, in the PAM ADR Committee 2020 and also 2021 is actually led by our chairman, Architect Stephen Tang, and together with myself, Architect Daniel Chu and Architect Hazri as the co-chairman. We also have a list of very active members that contribute in the committee. They are Architect Leong, Architect Minaha, Architect Abbas Singh, Architect Kopende, Architect Lim Fang Kyong, Architect Chong Pui Jin, Architect Ji Hin, David Ye, and also Engineer P.E. Chong. Okay, PAN ADR Committee is with a strategy to direct the PAN resources on projects, program, and to upgrade the core competency, skills, knowledge, and the professionalism of the member in the area. This includes the design, project management, contract management, design, build, and development in order to maintain relevant the competitiveness of our members and also the industry players. In ADR committee itself, we train potential arbitrators, we train adjudicators, mediators, as well as experts. From time to time, we also organize internal dialogue among the PAM arbitrators and the committee members for better and improvements. We also accept and review application of appointments of arbitrators, educators, mediators, and also experts. At the same time, we also collaborate with our PAN CPD committee, other institutes such as MIUP, CIUP, and IICS to organize and conduct a series of lectures in ADR. We know our PAM ADR rules to make sure that it's good enough and then it's up to the standards. At the same time, we also establish, review, and maintain our annual panels of the PAM arbitrators, mediators, educators, and also experts. So one of the recent interesting activities that the PAM ADR committee was visit to the construction court of Kuala Lumpur, and we also have a very good conversation with the construction court of judge. Okay, without further ado, I think it's a very short brief on our ADR committee. I hand over back the session to my fellow moderator, Architect Alice Leong, and also our speaker, Architect David Ye. Thank you.
Thank you so much, Architect Daniel. Thank you so much. So ladies and gentlemen, today's sessions is with the topics of introductions to evaluate the mediations for construction dispute. We will actually focus on the matters related to dispute problems and conflict faced in our industry, especially with the impact created by the epidemics of COVID-19. I'm very sure many of us heard about the COVID-19 acts implemented recently, but however, how exactly the acts actually affect or give the impacts and how it can be implemented into the ADR for our construction dispute. So we do know the construction activities often include activities which are, sequentials, corresponding, and or interconnect, that it may not always be practical to determine in the constructions contract which activities fall within or outside of the relief in the COVID-19 Act. So our speakers of these sessions will enlighten us through his sharings later. So let me introduce for a very short introduction of our speakers, Architect David Yet. So Architect David is a chartered professional architect. He's also in ADR providers, a fire engineers, expert witness, educator, visiting architecture critiques, and as well as Chinese metaphysics consultant. So he is also the PAM corporate members, as well as the members of the Malaysia Institute of Interior Designer. So besides that, he is also the Malaysian Institute of Arbitrator, Hong Kong Institutes of the Consultants Educator, as well as the Institutions of Fire Engineer UK and the Royal Institutes of British Architect. He's currently a consultant architect for his own private practices under the style of David Yet Architect, claim consultants and educators of DYA plus C ADR Chamber. Directors for projects, affinities, consultancy providing project management under one roof, and founding partners of Feng Shui. So without further ado, let us welcome Architect David. And David, I'll hand over the screens to you and you may begin with your presentation. Architect David.
Hey, hello. That was a very nice introduction, Alice. Good morning to all. I'm not able to share my video because can the people from the PAM allow me to share video?
Yep. Host, please allow the multiple share so our speakers are able to share the video and his presentation slide. Thank you. Again, I would like to request our PAM host, please.
We have shared. Yeah, I see.
Okay.
Yeah,
it's on already. Thank you very much. Okay, good morning, everybody. Let me try to share my screen. Just hold on a while. I have to fiddle a bit with this new technology. Okay, can you see my screen?
Yes, we can see.
Oops, the wrong one. Just hold on a while. Okay. Well, that will do. All right, good morning. Can I start my session for the day? Okay, welcome everybody to this topic of mediation. And the main thing is because what we are having here is, this onslaught of this COVID, and there has been a lot of issue on site, especially with contractors. They are not actually equipped to actually handle. Suddenly there is this COVID coming in, suddenly there's this MCO, and suddenly there's so much work disruption. And the worst case scenario is they are looking at situation whereby they have to provide for all these compliance to SOP, and to actually add to the matter, they are not sure what if the situation when there is a COVID case within their workforce, they will be shut down. But after that, what is going to happen? And the risk definitely will translate into the issue of cost and time. All right. And our PAM contract do not have a clear condition as to address the matter of pandemic. There is a force majeure, okay, on epidemic, but in a situation of a pandemic of this scale, nobody has actually seen, maybe this is the first time also in my life and many other people, they have never seen a situation whereby this is so global. Therefore, if we argue on the sense that this is contractual, whose contractual right, whether is it the right of the contractor to claim or the rights of the developer not to pay for the extra. So if you continue to argue on that sense, at the end of the day, the one who suffers is the project, including the consultant. And as you can see, nobody actually understands the impact of this COVID-19. More importantly, in the construction industry, suddenly you will also see that PAM actually issue an advisory. Now, the first advisory that came out was quite a novel thing, because it suddenly says that everything has to be force majeure, and the contractor was trying to face reality that if it's under force majeure, they can't even claim for costs. You see, and this is real that there is cost implication. You have to get all those SOP in place and so on and so forth. At that point of time, there isn't even an SOP to begin with. So that's the difficult part of it when the industry is looking at. And of course, on my side, I'm a bit I get some jobs in the sense that contractor has been calling me up, ask me, hey David, how to go about this, Then at the same time, of course, on my side, I will be frantically writing letters on behalf of the contractors and so on and so forth. But on the hindsight, even our projects also get affected. And the more important thing is that I do have the privilege of actually reading certain reply from other architects, on their job basis, and they, of course, they will stick true to the contractual clauses and so on and so forth. You can't do this, you can't do that, it's force majeure because PAM says so. But if you look through the whole scheme of things and you look at the contract clauses, there are many things that the architect can actually do to assist in that situation. And good enough as everybody begins to get into this COVID-19 pandemic issue and to actually have the SOP in place, we begin to realize that no, in actual fact, the architect is actually in the position to help the parties to agree on certain things that they have not foreseen. But there is another problem. You know what is it? You look at the latest advisory from PAM is to actually ask the architect to be negotiator, meaning to say the architect is now in a position to actually renegotiate the contract on behalf of both parties. Now that is a very challenging task because not all architects are legally trained, and further to that, if you ask the architect to do a negotiation on certain thing, you are actually risking yourself to be an impartial evaluator. You have to be impartial in the sense that, end of the day, the certificate is going to be issued by you as an architect, and that can be actually challenged. Although the recent finding of the court says that the architect has got no obligation in tort to the contractor. Surprisingly, that was the L3 case. Okay. But in the far side where your project is of the concern, you better know how to renegotiate this particular contract. And the negotiation, or rather the art of negotiation, is actually part and parcel of mediation. All right. The thing is this: when you start to renegotiate your contract, you do not have a fundamental legal provision to support or to actually give you the immunity as a negotiator, then you will actually have a problem. Because ultimately, if the one party finds that they are not able to negotiate or to get their terms right, they will say, then this is the architect to help me to negotiate. So again, you will be in the situation of difficulty. So For these purposes, we are going through the just an introduction of what mediation is for the construction industry. All right, there are many mediations out there. You have this scheme by MMC, Malaysian Mediation Center. You also have the AIAC. But most of the mediation that's done by the MMC is basically on other issues like medical insurance and also financial. Sometimes they also do mediation for family, like parents quarrel one another, children is not helpful and so on and so forth. So that kind of generic mediations, the approach is a little bit more different from our construction mediation, because our construction mediation basically is annexed to the skill of the mediator as being somebody who is expert in the field of construction. So don't have to be worried. We'll get through all these salient features as we go through the slides. Now, in the mediation, we look at there's only 5 stages, all right? So I give you an overview of what you will go through in the mediation session. Just so on, sorry. The first one is we are talking about the preparation. Now, in other forms of mediation, the preparation is very, very limited. The most you have is maybe one A4 size write-up of the case. So you are able to understand the case before you actually go and talk to the participants in the mediation. But in the construction mediation, it's totally different. You see, in the construction mediation, usually both parties will have their own lawyers to actually prepare the bundles. We call this the bundles because there's a lot of issues. So they'll prepare their own claims, and the other side will have their own counterclaims, and they have all these bundles of issues that they want the mediator to understand and help them to resolve. This is important because having the lawyer to actually come in to help the parties to actually prepare their claims, number one. The architect as a mediator will not have to resume the responsibility of not getting the information right, all right? Because all this fundamental information is to be prepared by the lawyers. And second thing, the lawyers are going to like you because they have got a job to do, and they are being seen as doing something for their client. Okay, so let them do their job. So with this bundle of documents, the mediator will have to go through it. And of course, there is a lot of documents. So it's unlike other kind of mediation. The construction mediation require the mediator to actually understand the issues and also all the supporting documents. You may or may not need that information at the end of the day, but you just have to go through it. That actually makes you different from other forms of mediation. Right? So this preparation of pre-mediation is very important. And also you will need to have this pre-mediation session to actually talk to the lawyers of the representative. Let them understand their role, after this, what are they supposed to do, So they are not supposed to go in the mediation and start to defend the rights of their client. Because mediation is not talking about legal rights. It's just talking about how you want to find ways to settle an issue amicably between one another. So this is very important to actually give a role to the lawyers to play, at the same time not allowing them to come in and derail the entire mediation process. So this pre-mediation is very, very, very important. Now, the next stage you will go through is during the mediation. Of course, you will introduce yourself and all the parties in the mediation. And that could also include the lawyer. But since you have spoken to the lawyer to take a secondary role, they will just be there as observer. Okay? Sometimes parties may find themselves to be at ease when they are represented by their legal representatives. So let it be. As long as the party is confident and they are willing to actually sit down and settle things, it's all right, okay? But only problem is when the lawyers begin to open their mouth and say that the rights of my client is this and this and this, and then the problem will start to come in, okay? Therefore, your opening as a mediator is very important, because in the opening, you will actually set certain ground rules, what can be done and what cannot be done in the mediation. So one very important ground rule is actually to ask the lawyer to keep their mouth zipped for a while, and if necessary only, the client and their respective lawyer can actually consult one another off the room, go out and consult, and then come back and get a resolution out of that. Other than that, is the duty of the advocates is actually to keep quiet during the mediation. And more importantly is that, of course, you have got two parties. If two parties has already got a dispute, there's some emotion things will also step in, you see. So one may not be able to see the other face, you know, front to front, you know. So as a mediator, you will have to confront the situation, and you cannot also be too a control freak, you know. You have to allow both of them to vent their frustration. But if by venting the frustration, you're not able to proceed, then that is a problem. So there is a lot of rules, or we can say skill, to actually mediate the entire situation. Therefore, part of the training of mediation is actually to have this skill, the soft skill, to actually allow people to say what they need to say, at the same time to control the situation so that it is manageable. All right. Then after the opening statement, it can, that means to say, one party will start to say, what is the issue? And after that, you give opportunity to the other party to say their issues or their counterclaim. So after that, you may want to say, okay, it's good enough. Let's find a little bit more about the concerns of the party, and you break them up into private session. So we call this exploration. So in this exploration, you goes into understanding the issue, and you try to find out the what is the common ground between the parties. There are ways to actually find out what is the common ground. Sometimes the common ground is totally unrelated to the construction matter. For example, face value. You know, if you deal with, let's say, a Japanese contractor, they don't mind actually making a loss, but they cannot be seen making a loss. So the issue of face value is important. All right, and when this exploration, when you have heard the issues that is being brought up by the parties, you can understand or roughly come to a certain conclusion. But then you cannot say it out loud. Then you break the peoples into this private caucus. You speak to one party at a time. Okay? And now that's the difference between the construction mediation and the rest of the mediation. Is that in the construction mediation, the mediator is deemed to be an expert in their field. In other words, it means to say the mediator can actually bring in their opinion and to be tabled to the participant and let them understand. Okay, let's just say if you're an architect, okay, you ask the situation like COVID, then you tell the developer, okay, come on, be fair, look at the situation. Nobody has ever encountered this problem before, right? You know, if you are in the shoe of a contractor, you were also having all this risk that is coming out without really knowing what you have entered into. But ultimately, end of the day, the project suffers. It's not really the contractor, although they don't make their money, but at the end, the contract suffers, or rather the project suffers. So you can actually bring in your opinion into the table for discussion. Now, in other forms of mediation, like in a family dispute, you cannot bring in your opinion. You have to be just a facilitating party to actually tell the other two parties, hey, what do you think you can do to move forward the situation? You know, you can only coerce them to actually come up with their own solution. you cannot give opinion. But in the construction mediation, you can, because you are deemed to be an expert in the field. Therefore, as a construction mediator, you are supposed to negotiate based on a certain set of criteria that you deem to have as an expert in your particular field. So that is a big difference compared to the rest of the form of mediation. And when you find that both parties has actually something in common and they can actually agree on certain things, then you begin to say, okay, let's meet up together. Both parties meet up together. And as I can see, this is what you need, and this is what the other party needs. So I can find certain common ground, and let's agree on this common ground. So you bring both parties together and you spell it out all the terms that is both agreeable, and you move on from there. So if the terms are agreeable by both parties, by the time you say out loud, they will have no objection. For example, if in the case of the contractor, they say, okay, let's look at this. Look at this situation. I know the developer has got issue of selling the houses or the unit because of this pandemic. Okay, why don't I offset some of my claim by just contra with these units or apartments? So there are many options. Therefore, go back to the exploration stage where you have got a lot of option generation. You are supposed to look at option 1, option 2, option 3, and see which is the one that is most attuned to either party to concur. So once you have all this agreement or all this term that is agreeable, as a mediator, you are supposed to prepare the terms for the participants. But you are not expected to actually draft the entire agreement, negotiated agreement. Okay, you can leave that to the respective legal representative of the parties to do so. So after that, you concur, let them sign on the piece of paper with all the agreed terms, pass the agreed terms back to their respective lawyers to actually draft out a proper agreement, and that's it, your job is done. Okay, simple. There is a procedure to this, so it's not simply negotiation means to say a tabletop, you know. Because remember, whatever that has been spoken during a negotiation can be taken to go against the negotiator. Therefore, it is very important for mediation that both parties sign a mediation agreement, and that particular agreement is actually giving immunity to the mediator to conduct their mediation and also their negotiation accordingly. All right. So PAM as an institution will have this what we call the institutionalized mediation, where the coordination will be done by the institute, for example, PAM. Now, party will just have to write into in PAM case, it will be the PAM president, an application for mediation. And of course, during that application, both parties must concur, must agree to take up mediation as a means to resolve the dispute. Now look at this situation. Let us say a project, your own project, you are the architect. Now, there is a problem arise. Instead of spending the money, go for litigation, arbitration, adjudication, you can say, okay, why don't we try mediation? Let's talk to each other, all right? Then as a project architect or the architect for that particular project, your capacity may be limited because you are the impartial certifier. You are not supposed to be seen biased to either party. So you can call your friend, another friend architect who is also a mediator, and say, okay, well, why don't I get a third party architect with a mediation qualification to come in to quickly resolve this thing, just half a day, you know, sometimes it drags to a day and get it done with. So you get your third party to come in, and of course the party will come in with their agreement to mediate. So each party agree to that, and you can already kickstart the mediation process. So it's going to be very quick. And once there is a successful agreement on certain term, That's it. You just continue on with your project, and at least both parties knows. Oh, okay, now the game, the rule of the game has changed slightly. Now, you know, instead of lose all and then maybe win all situation, now we have a win-win situation. So that is how it's going to be. But unlike that, that is very ad hoc. Okay. Unlike that, the institution mediation has a certain procedure, and of course, the first procedure is mediation. The second procedure is you'll be given an agreement to mediate. At this point of time, PAM do not have the agreement to mediate because the agreement to mediate for each of the mediator will be different. Most of the mediator may have been trained in a certain way or another, but the aspect of their trainings will enable them to actually come up with a different forms of agreement to mediate. For example, for construction dispute, there is an agreement to mediate with a clause stating very clearly that the mediator is either being indemnified, and whatever is spoken by him or whatever suggestion that has been given by him cannot be brought to the court of law in case that both parties disagree. Something similar to that. So that piece of agreement to mediate actually protects the mediator. Right? So you cannot just simply go out there and start to negotiate for the parties without knowing you are actually should be indemnified in the first place. If you do so without having this proper agreement to mediate, you're asking for trouble. Because in mediation, there's a mediation act, all right, that's supposed to protect all the parties regarding mediation. Then, of course, the PAM will do a nomination. They will give a list of the mediator to the parties to choose. Usually come in 3, A, B, C. Now, party may say that, oh, I have my own preferred mediator. Please, whenever people say, can I put your name as a preferred mediator? The moment your name is put in as a preferred mediator, you will never get the mediation job. The reason is very simple. If party A's name so and so to be mediator, do you think party B will agree to that proposal by party A? You definitely will not agree. So end of the day, the whole issue will be brought back to the president of PAM to actually nominate. And seeing the situation as it is, the PAM president will definitely not put your name inside. If both parties has agreed, there's no reason the PAM president has to nominate, right? So it's a catch-22 situation. So never get parties to actually put your name as their preferred mediator, unless you actually go ad hoc, right? Now, the fees and term of appointment, of course, the fees and terms of appointment, there is a institutionalized set of fee and terms of appointment. But because we are in a situation that under the what we call the Non-Competition Act or the Competition Act, the mediator is supposed to negotiate their fee with the parties. So you do need to have your own fee, and you do need to have your own quotation to be agreed upon by both parties. But at this moment in time, let's face the reality. A lot of mediation out there is on pro bono basis. Why is it on pro bono basis? Because number one, they want to make mediation as a preferred choice among all the others. So they want to let people to get a sense of what mediation is all about. And when people see the efficacy and the effects of mediation, then they are more willing to pay for mediators. So this is the situation at hand now. If you look at AIC, they are doing pro bono. Even the COVID-19 Mediation Center, they also do the pro bono. Of course, that will be paid by the government. Now, other than that, there will be this independent and impartial declaration. That means to say the mediator involved to renegotiate the contract for you is actually an independent person. So if it's related to your own project, if you want to do the negotiation or the mediation part of it, you are risking yourself. You know, end of the day, whatever decision you make may go to the court and be thrown out because you are deemed to be impartial. Then the other thing is, of course, the institution will prepare the bundles and all the fact sheet ready. So they will coordinate this. Of course, in the ad hoc, mean to say it's agreement by both parties, all this will not come in. You will have to, as a mediator, you have to arrange for the receiving of the bundles, and the collection of the position statements and so on and so forth, right? So this is the difference between the institutionalized mediation and the ad hoc methods. Now, this particular flow chart tell you the institutionalized, okay, in terms of timing. Now, every party can actually apply if there is a mediation clause in their construction contract. Now, remember the PAM form construction dispute, we call the dispute clause. It's not a multi-tier dispute clause, meaning to say it never states that before you can do arbitration, you have to do adjudication, you have to do mediation. No. So mediation is a freestanding. That means parties can opt to do mediation concurrent with other forms of ADR solution that is available in the PAM form. So the application will usually be written by one party and the submission to mediation by the other disputing parties. Now this will be coordinated by PAM. So within 21 days, we have to decide whether we can go or not go for the mediation. All right. So on these 21 days, a lot of things happen. Right. For example, 14 days, the PAM president would be actually giving a list of the mediators to choose from. And upon that 7 days, PAM will appoint the mediator because you need to give time for the mediator to negotiate their fee and so on and so forth. Then you have to allow the mediator to understand the position of both parties because we're talking about bundles of documents. It's not just one page of A4, right? Then only the statement of mediations come in, and 3 days thereafter, you can have the mediation session. And of course, the rule, PAM rule will say there is 90 days to conclude the mediation. You don't actually need 90 days. You may need more days to understand the position of the parties, but you need maybe 1 day or 2 days the most to actually conclude the entire mediation. The reason is because there is a lot of, we call it a shuttle diplomacy. There's a lot of going through and forth between one party to another party. You get certain terms from party A, you bring the terms to party B, and party B may have the option C, and then you bring back the terms to option C to party A. You know, there's a lot of this shuttling diplomacy between the parties before they can actually concur on certain things. So that takes time. Usually before the pandemic, it happens in a hotel, you know, where you can have different meeting rooms whereby you can actually go through the meeting rooms here and there and spend days in the hotel doing this. Then in the situation of COVID, we will have to do this like now we are doing, you know, the virtual mediation through the internet and Zoom. So mediators also needs to change a little bit. We have to now talk in facing the camera. So one problem is it's very difficult to actually gauge the acceptance of certain things by not able to read their body language, right? So in that situation, mediators should actually tell parties, okay, even the camera, we need to look at your shoulders, we need to look at your, you know, your hand gesture and so on and so forth. So we can gauge roughly whether the party agrees to a certain options that is brought forward, you know, or they totally are not there to accept anything at all. So these are the things that need to fine-tune using the Zoom mediation technique. Of course, the institutional requirements we're looking at here, the principle of the institution administered mediation, for example, the RCS model, they call this the ACRE model. Now, what does the ACRE model stand for? The A stands for analytical. That means to say they expect mediator to actually analyze the whole entire situation to see what are the common points that the parties can agree and move on from that. So the analytical part is very important. Then there is a commercial, meaning to say, if you look at this particular ACRE model, it's not suitable at all for family. It's not suitable at all for marital issue. This ACRE model is only attuned to commercial dispute, including construction dispute. Because construction dispute, the main thing is time and cost. So it's commercial related. Therefore, the ACRE model works fine in this situation. And more importantly, it's restorative. Meaning, you say, end of the day, the disputing party will not look at one another as enemy. They will say that both parties actually is civilized in the sense that they will want to iron out their issue in an amicable manner. So in future, there is always a chance to work together again, and by doing mediation, they could actually understand each other even more. Therefore, the restorative part is important in our construction mediation. And of course, the last one is expert, whereby the mediator themselves is actually the expert in the construction industry. You don't get, let's just say, a general practitioner of law to come in to actually mediate a construction dispute, because he may not understand the bolts and nuts of construction. Okay, therefore, if you look at certain institutions like the CIR and things like that, they may come to tell you, oh, we have something called a neutral evaluator, whereby they will come in and give you expert opinion on certain things. That is the reason, because the mediator themselves, having trained as a lawyer, they may not understand what the construction industry needs. Therefore, they need to have this third party neutral evaluator to come in to give them inputs. That means to say you have extra charges, extra costs, extra time. No, we should not look at this at all. In the construction, let the construction guys get this thing done. All right. Therefore, in PAM or in ICS, in this instance, they are looking at people who have this core expertise to be the mediator themselves. All right. And as with all institutionalized mediation, the very important thing is the mediation group. Because in the mediation group, there must be certain mechanism of flexibility given to the mediator to allow them to actually propose their opinion. Besides the party's opinion, they can bring up the third thing, which is the mediator's opinion into the table. Nothing is binding until the parties agree to accept your opinion or not. You see? So this is very important. This is a synergy concept. 1 + 1 is equal to 3. Okay? So the mediation rules must be there, and also there must be a guide to mediation, the proper procedure. Then we look at the ethics qualification of mediators. Of course, mediation is a soft skill. Even if you don't use the skill to mediate a dispute between parties, you can actually acquire the skill to sweet talk your contractor, sweet talk your employer, End of the day, your project has got no dispute, no issue. I mean, that is the ultimate thing everybody is looking at. Am I right? So it's a soft skill that I think all architects has to have, And the mediators, of course, if you talk about PAM, there is this mediator empanelment, whereby you can give your name to be a mediator for a certain institute like PAM or AIAC. Of course, there is a standard form of a mediation agreement. At this moment, I don't think PAM has one. All right, and there is a standard fee and cost of mediation. Yes. Then, of course, you have the terms of appointment for mediator. And of course, this term of appointments, it may change different from one mediator to another. All right, you can actually customize your terms. Okay, now there is a big concern in the mediation field that whether should the mediator be also impartial, meaning say the mediator don't even mention their opinion at all. Because you have to look at the Mediation Act Malaysia. Sorry. The Mediation Act in Malaysia is being drafted based on the MMC model for generic types of mediation. Meaning to say it can cater for financial, it can cater for family, marital, and so on and so forth. So it covers a large scope. Therefore, in that kind of mediation, the mediator only facilitates the party to come to their own terms of agreement. the mediator cannot put in their suggestion. All right. If in any event during the mediation process, one party feels that the mediator has made a suggestion, that's it, the mediation fails. But the argument here is, if there is a strictly facilitative mediations, it is actually a waste of time. Because if both parties can actually talk to one another to resolve their dispute, they don't even need a mediation to begin with, right? It's because both parties cannot agree on certain things. They need a third party to come and conceptualize or crystallize their needs into a win-win situation. Therefore, they need mediation. So in a lot of mediation, generic mediation, if you were to apply to the construction industry, it's going to be total failure. Because one party will say, I want A, B, C, D, and the other party will say, I want E, F, G. So it's totally different things altogether. You cannot facilitate in such a manner, right? Therefore, we have this term called evaluative, whereby the mediator can actually bring his own input into the discussion, okay? But in our evaluative mediation, we will always start with facilitative because we want parties to actually bring up their own way to resolve a certain issue. This is very important. But when they are not able to, then only the mediator can actually suggest, why don't we look at this thing in another way? Why don't we look at the other option, you know? So this is where the input of the mediator is important. And this is the crux of the RCS model, all right? We have yet to find an acronym for PAM, but we are in the process of doing so. In the mediation agreement, generally, if you look at the flow chart, now we go to the stage of getting people to agree to mediate. So in the recital, you will have this agreement made between who and who is the mediator. So this party has to be identified. Okay. The general scope is that parties agree to mediate and the mediator agreed to accept such an appointment. And the mediation should be conducted under what rule? So if you go to the AIC, they will follow the AIC. If you go to PAM, you follow the PAM rule. Now, the parties are not bound by the comments of the mediator. This is important. Some mediation agreement does not contain this clause, but in our construction phase, we should have this clause because we do not want the party to bound by our opinion. We just suggest only whether they agree or not is vested upon themselves. So we do not want them to be bound by our comment. All right. And we allow the parties, advisors to jointly and separately involved in the mediation. But you have to set the rule very, very clearly. If you want the lawyers to be involved, to what stage the lawyer must be involved? You know, we don't want the whole entire mediation will be arena where one lawyer A and argue with the other lawyer B on the merits of law. That is not what we want in the mediation. So you have to put down your feet. You have to do the rule of mediation so that you put these people in their proper role. Then very important is both parties has to cooperate in good faith. If one party just refuses to mediate, no point doing mediation at all. You know, you will definitely not get through. And the other important thing is the representation by person with full authority. You don't talk for days, end of the day, the person come back, I do not have the authority from the board of directors to decide on this. Hey, you spend so much hour talking, you know. End of the day, the guy can't agree on certain thing and the guy has got no authority to agree. You are wasting everybody's time. So, no, those people that is in the mediation must be able to make the decision on the spot. Of course, the good thing is the mediator will be meeting the CEO or the managing directors or those decision maker of the company. You're not looking at the project managers and so on and so forth. All right. So this is important. So these are the scope that should be reflected in the mediation agreement. I don't have the liberty to show you the complete mediation agreement, but generally these are the main scope that should be incorporated. So the other scopes will be disclosure. This is important. Now, if both parties were to do a disclosure to the mediator, it has to be confidential. Unless the other party agrees to actually allow the other party to know what he has relayed to you. For example, you talk to party A, then you have, before you talk to party A, you must tell him whatever spoken here is confidential between you and me. Unless you want to tell me to relay certain information to the other party to confer. You have to get this permission. If not, your entire mediation will be derailed. Let me tell you the truth. Sometimes mediator may carry away with their mediation because they may have this issue. They want the mediation to be successful. Please, if you have this thing in your mind, your mediation fails. You cannot push the party to agree certain things they are not ready to agree. All right. Therefore, you have to look at them for mediation as a neutral party. Whether they agree or not agree is their problem, is their business. You are there to actually make sure that they follow a certain criteria to come to a certain agreement. That is important. Okay? And of course, there is certain disclosure that the mediator can give under the law. Okay? If during the session of mediation, there is a potential threat to injury and also damages. Because if these are the thing happens, it's under criminal. You're supposed to make a police report. All right. Other than that, no. So if there is a issue related to criminal, you have to stop the mediation and say to the parties, I cannot conclude anymore because it involves criminal. One of the issues that involve criminal is actually bribery. Right. In projects, I think that is quite common in Malaysia. So this is one issue that we cannot mediate. And you have to tell the parties the concept of without prejudice. Without prejudice is a legal words, mean to say that whatever recommendations of the mediator is actually without prejudice. You cannot bring it out of the room and make it into what we call the evidence in the court of law. You can't do that. So it's without prejudice. Okay, this covers statement made during the mediation by everybody, except if there is a criminal essence in it. The notes of the mediator, after you write down all the notes after the mediation, you're supposed to destroy the notes. Okay, including all the preparation of all the information, the bundles of documents, so on and so forth, and the settlement proposal. After they came out with the settlement agreement, your settlement proposal must be removed. So the other consideration will be the settlement proposal and also communication for the purpose of the mediation. So these are all the other criteria that comes into it. Then you have this enforcement, the terms of settlement agreement by judicial proceeding, and also the rights to terminate the process of mediation. So now the more important is the mediator's immunity for settlement, act or omission unless the act is fraudulent. Mean to say, mediator as human being may also make mistake, okay? But you will be immune. You know, the party cannot bring you to the court of law because you made a mistake. All right. Then the other thing is the parties may jointly separately indemnify the mediator, and parties jointly separately liable for, of course, your fee as a mediator, the rentals of the places, administrative and other costs. Then finally, you put the signature into the mediation agreement. Okay, I've covered this mediation agreement. Then we look at this. Of course, the agreement also has got this schedule 1, which is the nature of the dispute. Schedule 2 with all the administrative charges and so on and so forth, right? Now, preparations, we look at this open and clear conversation with the participants and the lawyers. Remember, do not discount the lawyer. When people go into dispute, the first thing they go to find is the lawyer. They don't go to find the architect. Remember that. Only when people wants to build their dream house, they will go to the architect. Or for the purpose of building, they need architect's signature to do the submission to the authority. Then they will go to the architect. But when people got dispute, they will go to the lawyer first. All right. So never discount the lawyer. You just need to give them a role and a position to play. So in this case, you have to manage expectation of the parties and yourself. You have to let them understand that there is a limitation to what you can and cannot do. I have already brought to your attention what you can and cannot do. And you also need to affirm that you may at any time decline to do so without needing to provide the reasons. That means you can actually call off the entire mediation without need to actually say why. Okay? Now, if the party expect you to give an expressive opinion, you may express in such a way that suggesting a way forward. Okay, this is only for evaluative, which is work very well in the construction industry. Okay. Then with the lawyers, of course, like I said earlier, you define what their roles will be. And with the parties, you can decide whether it's going to be a face-to-face, telephone, or Zoom mediation. And your approach of mediation have to make it clear. You have to tell them whether you're doing a facilitative or the evaluative, whether this mediation is going to cover for the entire day or it's going to cover a certain period of time, maybe 3-4 days. Then you will conduct your session in the joint session, or we call this shuttle diplomacy. You move from room to room, all right? Now, in any way, we need to have certain order of directions, whereby any directions needed, you have to tell them, okay? Then what other concerns are clear, you have to let them ventilate themselves. You have to identify the needs of the parties. Remember, mediation is not about who is right. Whose right is this? It's more about whether you need that or not. So the needs of the party comes in first. Then for the construction mediation, it's very important to have a pre-mediation meeting. You don't just go into a mediation, you need to have pre-mediation, because in the pre-mediation, you're going to brief the lawyers, you're going to look at all the bundles of documents that you have, and you're going to ask for clarity, because sometimes the bundle of documents may be arranged in such a way that you're not clear about what is actually contained there, and so you need to ask. Then only you see whether is there a need to have a joint or separate discussion with the parties involved. And always remember that even if you are an architect, you have to maintain a certain degree of transparency. For example, your CV, you have to state your qualification and your experience, and then and also your intention to run the entire process of mediation. And you have to let the party know about the limitation as to your liability and your immunity, your knowledge, the evidence that has been given, and also the entire process. Because unlike arbitration that can go on for years, mediation you don't. You will either settle in 1 or 2 days, or maybe half a day. Then also you talk about the inclination of the suggest opinion or otherwise, without the needs to give reasons. So this inherent power has to be given by the parties, not you, because it does not cover in the Mediation Act. And this is more talking about logistic, whether the bundle agreements is a separate bundle or the agreed bundle. And of course, what contained in the bundle of documents, especially with regard to construction dispute, will be the contracts, the certificates, the original file, the accepts of it, the statement of case, the witness statements, the expert reports, the inter-party correspondence, right? and they should be properly labeled and indexed. And you can actually limit the submission of bundles. Let's just say you limit by having, I only read within the 2 boxes of A4. You know, beyond that, I'm not going to read. So you can limit a certain submission. Therefore, it's good to actually give the role for the lawyers to play by getting them to help the parties to prepare this bundle of documents. So in the procedure for the mediator's opening statement, I'm running through the procedure. First, you do an opening statement, let all the parties know who are they in this mediation, and you introduce yourself. At the same time, you lay down your ground rules of mediation, and you say what can be done and what cannot be done. Then you allow the first participant to make an opening statement, usually the claimant, all right? You let them to vent out what they claim, right? Of course, sometimes the lawyers, they may be representing lawyers. The lawyers may do a little bit of opening statement by saying, oh, their client right is this. Then give the opportunity to the CEO concerned to actually say what they actually need, all right? Then after that, you do a summary of what the first participant's statement is. Then you go to the second participant and ask them to do an opening statement. After that, you conclude by having the summary of the second participant. Then you tell both parties, all right, now after hearing what you have to say, I think the agenda is this. Then you list down the agenda. We used to write it down in the marker board, but in Zoom mediation is difficult. So sometimes we just mention it out loud. Okay, this is the agenda we want to clear for today. All right. So you discuss the agenda. Okay, let's just say point number 1. Who is going to pay the cost for this compliant to SOP? Claimant, what do you think? The claimant will say his piece, and then suddenly the respondent will interject, say, no, in the contract, there's no mention that we have to bear the cost, you know. Then when there's a heated up argument, you can actually say that, okay, we may not be able to conclude in such a manner. Let's go to second agenda, then third agenda. You know, then you go through all the agenda, then you may say, okay, now to get more clarity, let's break it down into a private caucus where I can speak to one party at one time, right? So this is what the expected mediator should do during a first joint meeting. Then in the private caucus or the private meeting, you can do a lot of reality testing. Meaning to say, hey, come on, if this can't work, anything, you know, are you prepared for this? Now, let's just say he accepts this. Can you accept this or not? You know, so there is a lot of things done. This is where the negotiation part comes in. You know, you have to do the formality of getting all the other things done. Then only you go to negotiation. You don't straight away jump to negotiation, because if you straight away jump to negotiation, anything turns out wrong, you will be at fault. Okay, so during the private caucus, get the needs done, get the terms that they can agreeable, then only you call both parties together. Then that's where the settlement can be done and end up with a settlement agreement. Now, suddenly, during when they meet, there may be a change of thought, you know. One party may decide, hey, I'm not comfortable with certain things here. Then straight away, you have to break it back to the private caucus or the private meeting. You will say, sorry, guys, I think one of the participants may have a change of mind. Let's talk this privately again. So go back to private session, renegotiate. Never force the participant to agree. That is not your job. Your job is to facilitate, if in situation of deadlock, contribute your opinion to it. Okay? So it's okay if the end of the day, the settlement did not come through. So if both parties cannot settle, all the mediator has to do is to come out no settlement certificate. It just say that in this day, who and who came to a mediation and there is no settlement agreed. Sign, that's all. So they can go on with whatever they need to do, arbitration, litigation, and so on and so forth. All right? I think I've covered everything. So if you have any question, you can ask. go back to the moderator, Alice. Hi, Alice.
Okay, thank you, David. Wow, that is a very comprehensive and very informative presentations overall about the mediation. I will see that the concepts of I'll call it online dispute resolution, or in short terms I call it ODR, has been battled around for years, but before the pandemic especially, whether it is still unclear, whether it really can be implemented in the prime time. But looking at the situations of the pandemics, as well as the economy's condition may cause the cash flow, and they require taking the increase and the quick resolution. So I think mediation is another way of forms of resolving dispute in a much more quickly methods, towards the Skypes and Zooms. So I totally agree with you that if for people who have a encounter dispute in construction, please look for professionals that really know our construction terms, rather than just go to the bang into the lawyers or anybody parties that's not really familiar with the terms. It's just like your house. You have any problems, your plumber's problems, plumbing problem, you don't go for other people to resolve it, right? That's the same thing. So okay. Yeah. So I will ask you a little bit, some of the questions may be not so much on the procedure, because I think that you have shared very details that how mediation should be conducted and how it should be recording and how it goes and that. But I'm trying to relate back to the most recent things that the question is, if there are any dispute matters is already ongoing, the proceedings has been ongoing, before the pandemics, and in year 2020, then all this thing has been happens and thing has been delayed. So can in these situations, whether if any of the dispute party, can they actually, if both agree to to switch it back to say to mediation, is it okay to do that, or how?
There's no limit to that, actually. So it all depends on the party whether you want to bring in the issues before the pandemic. Sometimes there are also people who want to take mediation as a test bed before they actually go for a litigation or arbitration, to really test it out whether their claim can actually work or not. You see, because if you go full-fledged into litigation or arbitration, there's a big cost involved. So what they do is actually they do a test bed by using mediation. All right, so they can bring in all kinds of issues that related to their project. Not necessarily it has to be only the pandemic. There's the term of reference is given by the parties. The mediator will just have to address whatever given to them. Okay. Given by them, yes.
So just I think in the beginning I did mention about the COVID-19 Act implemented in Malaysia. I understand there's a big difference, the COVID-19 Acts in Malaysia as well as in Singapore, So and I believe not just our professions, but I think including all our fellows or teams that involving in this construction industry, many has been questions about and still many unclear about how this COVID-19 acts actually can resolve some of the matters in construction. For instance, the force majeure clause, So maybe you can share a bit. I know it's a bit a bit carried away from the mediation, but it still will lead to this kind of dispute that will again come back to mediations or educations or as well as arbitrations. So maybe you want to elaborate a little bit on that.
I thought that was a question for Joseph in another
really
another session. All right. Okay. Based on my understanding of the COVID Act, okay, of course, there's one part of the COVID Act that actually tells you that in this scenario, what can you bring the other party to the court of law on certain thing, or rather, if one party are not able to fulfill certain legal obligations of their contract, then what is the remedy? All right. And of course, they are very fast to conclude that why don't parties go for mediation first, you know, to settle all these things. Now, on the broad issue, the COVID Act is the act of Parliament has been rewritten the contract for the parties. You know, both parties may come to an agreement, but unfortunately with this act of Parliament, the contract of the party has been somehow been rewritten. Okay? Then the question is, after this contract has been rewritten, what is the procedure like? So in a lot of other countries, take for example in UK and so on and so forth, those forms that they use, the NEC forms, the FIDIC forms, each of them, even the JCT forms, each of these institutions actually came out with an advisory. Their advisory is looking at the provision of the contract and how to go about it in claiming for time and claiming for costs under the situation of the pandemic. And they make it very, very clear. The procedural aspect is very clear because they know that in certain jurisdictions, their agreement may have been altered by an act of Parliament, just like what we have here in Malaysia. But the operational part of under their prescribed form, how to work within the ambit of their forms or ambit of the clauses within their form. Now, these are things that is not forthcoming, unfortunately, with PAM form. Until today, I think most of the architects is struggling to understand how can we utilize the clauses within the PAM form to actually mitigate the entire situation. You may not even need to go into mediation if, as a contract administrator, you know the option that is available. So my disagreement in the first place is we are too fast to come up with an advisory to say that it's a force majeure. Because ultimately, some party will take this as a reason to tell, oh, you want perhaps this is force majeure. You cannot claim costs, you know. What can you do?
Yeah, true.
Right.
I heard that too. Yes.
So it's very, very biased in that sense, you know, because both contractual parties have to come to this situation. Suddenly, PAM will come in and say it's a force majeure. No, there are other possibilities. There are other clauses that we can look at. We are not saying that everything is going to be a win-win situation here. There will be a cost-benefit issue, all right? But let's let the party to have a clear mind to look at it. And then, of course, as architect, we don't try to muddle the situation. Don't make it murkier by having just one conclusion. Okay, I've read some of the very distinguished architects that actually wrote into the parties and say, this is unprecedented situation. Why don't we sit down and talk it over? With the kind of just a simple letter like that, I mean, as a contractor or whoever, there is a clear conscience that people are willing to talk it rather than saying, oh, this is my right, that is your right. No. And then how would the general public look at the role of the architect? If the architect were to say, let's talk it over. You see, that means there is an opportunity given to both parties, not one party, but both parties. Remember that. And there's a lot of time when we, architect, when we write a letter, we always do a conclusion before our reasoning. We always say, the contractor cannot do this, that, you know, cannot claim for this, cannot, or I totally disagree with your claim. And no, you can't do that. You must write in such a way that, okay, I have heard you. This is what you were trying to tell me, am I right? Then I also take the response from the employer, and the employer has this to say, blah, 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 blah. And therefore, I come to a conclusion that this is what we should do. Now, having said that, after reading this kind of letter, wouldn't you think that as a contractor, my architect has given me a chance to be heard?
Yes.
It's totally different, you know. So sometimes the dispute stems from the architect themselves rather than the parties, because, you know, contractor just want to finish his job and get his money, move on. Developer will just once the things get built and move on. So as the role of an architect, we have to do that. right?
Yes.
So it's some kind of an art of mediation involved, so because you do an active listening, you listen to both parties and you come to a conclusion.
Exactly. I totally agree with it because recently also I heard a lot of from other parties, means from the contractor side, they are not in my jobs anyway, but they did actually say that, oh, the architects there, you know, especially they will emphasize, it's not my opinion anyway, they will emphasize on the younger generations architects, you know, they are actually, they're holding the contracts, you know, you must, and you cannot, you're not entitled. So you see a lot of things that is not a death sentence to me. Of course, my view is that we have to understand the whole contract in depth and wisely implemented it. It doesn't mean that we have to go against our contracts. We still follow, but there's a way, a soft way, as you say, to resolve this, so that they will actually reduce this kind of unnecessary dispute. You see?
Yeah, correct. You have to bear in mind, in our jurisdiction, we follow the common law jurisdiction. The idea or the concept of what we call this good faith does not really make any sense.
Yeah. So David, what do you think that and how important is actually this collaboration between all parties, you know, especially in one project, you know, to avoid this kind of disputes, you know, how important is this? You know, I found that certain projects that you know, when I mention all parties, could be not just architects but your consultants, then you have the developers, then your contractors, MSC, and so on and so forth. You know, so maybe you just want to give your opinions that, you know, this kind of collaboration is between, you know, how important is it, so that our participants, whether they are in the backgrounds or doing the resolving the dispute, or they are just a practicing architect, so at least they know that as a lead consultants, that how we should actually put everybody's together and do to break through all this kind of unnecessary shells, you know. I find it always happens, you know, that people always protect their layer, you know, invisible shell in front of you, that, you know, that kind of things. So maybe you want to talk about a little bit on this.
This is a little bit off of topic.
Yeah, because why? If the collaboration is not well being carried out, then of course it always lead to the dispute. You see, because you and me, we are practicing, and we are also in many you know, taking many other extra professionals knowledge, and see how to do this. So it's always to me, it's always a battle in between. So when I run a project, I would not wanted my projects to lead into this kind of dispute. But in the other hand, that you actually providing this kind of service, you know. So but I always hoping that for myself, my own projects, it won't come into these situations, you know. So I mean,
Okay.
just advice from a point of view as a people that giving services as the mediators or the arbitrators, things like that, you know.
All right. There are multifaceted questions that you have asked here. Number one, if I can recall, your first question that you asked is regarding young practitioners. Right. Of course, as a young practitioner, we are inexperienced in the first place, and sometimes we have been thrown in a situation where we have to learn, and our learning curve is so steep. You know, sometimes we are gasping for oxygen. And worst case scenario is you don't have a good mentor to actually get you through. All right.
Yes.
In the situation of hard knock, always go back to fundamental common sense. Common sense will tell you if you want to have a good delivery of a project, number one is the relationship of the parties in the project has to be good. And the second question that comes to mind is what builds relationship? Not what has relationship, what builds relationship. First thing in the list is communication builds relationship. Very important to establish certain communication. If you need to talk, please do so. If you need to let people know you're thinking, please say that out loud. You have no choice. But then when you have got too many people wants their needs to be fulfilled, that's where dispute come in, right? Everybody wants to champion your own rights. Then that is where you need to have certain skill as a mediator to actually distinguish between needs and rights. Not all rights can be fulfilled, but you can at least mitigate the needs of the party. So put other people before you, meaning to say you bring out other people's need to the front and discuss about the needs and see how to go about it. If nothing can be achieved, so sorry, we have at least tried, you know. So this is very, very important. And that kind of attitude must be translated from you having meetings with people to all the way to the way you communicate with people in writing. One example in writing that I have demonstrated to you just now, right? So you listen to other people first, and then you make a conclusion. Then nobody is going to be say you are fault. Even you make the wrong conclusion, it's still okay, because there's always subsequent way to rectify it. But if suddenly you come in the point and say your opinion or your conclusion out loud before allowing other people to talk about it, then people will start to feel you're being very biased to a certain party. Am I right?
Correct.
Especially between consultants, you know, there is a lot of other consultants who would like to hide behind the architect's back. You know what I'm saying, right? They always take the architect as the big brother, you know, hey, please help us, you know, even we know that we have done a mistake, you know, I don't want to look bad in front of the client.
Correct.
That kind of situation. So more importantly, you must understand that in the construction contract is between the contractor and the employer. You have no role. Your role is just to be in between only. Okay, so make sure that both of them feels that their needs are being heard. They may not be satisfactorily given or entertained, but at least they are being heard. That is the most important thing.
Yeah. So
okay,
one more last very short questions, and I always very curious about that. So if you already become a mediator employed by, you know, appointed by the two, agreed and appointed by the two parties, so understand that there's a duration for the mediation. So what if during that durations that, you know, when you attended certain functions or going somewhere else and you may bump into, you know, one of the parties. So is that at fault if anybody's taken a picture and said that, then they can claim you actually, you're not in the fair situations?
That is a examination question, I suppose.
Yeah, not really examination question. I believe always, even though after the examination, because in those days, yes, but nowadays that because we are entered into the era of you know, the technologies and everything, and a lot of this kind of broad networkings and so on and so forth. So is this thing is still I find it's quite tight anyway. So is the mediators get caught by just one pictures? Is it in fault for that?
Okay, in the UK Court of Law, there's a recent court cases that actually brought to the attention that it applies actually to arbitrator first. All right, the issue of this impartiality and independence, and of course, there in the dispute resolution arena, we always fall back to what we call the soft law. The soft law are not law, are not statute. Therefore, it is called soft, which means to say this is guiding principle. It's not law, it's not mandatory, but it's a guiding principle. And the guiding principle that most of the ADR practitioners actually follow is the IBA guides to non-conflict and so on and so forth. So in these IBA guidelines, they do have this the yellow list, the orange list, and the red list, and also the. So if you fall within the red list, that means to say you are not being very impartial. You are related. So back to the question, that if you happen to be a speaker like what I am here, and suddenly somebody took my picture together with you, and you have a case, and suddenly I appear to be your mediator, would that actually say that I'm being very impartial? So in that list, where the green list is stated very clearly that appearance as a speaker, as a writer, in any open event, it's not construed as being not impartial in that sense. So it's because that's why it's fallen under within the green list. Of course, the other side of the lawyer will say that no, because this is soft law, this is not hard law. No, I don't buy this shit. But generally, institutionalized mediation and things, they would actually follow certain regulation in the soft law. And soft law plays a very important role as governing the conduct and also the transparency. That's why the IBA stands for International Bar Association. That means it's made by the lawyer themselves. So how could another lawyer going to contradict themselves by saying, I'm not going to follow the IBA? So exactly. It's a bit a gray situation in this area, but generally we accept that if it's under the green list, it's still okay. Even the orange list is okay, the yellow list is okay, but the red is divided into one is okay, one is absolutely not okay.
Hey, thank you.
That would be the guiding principle.
Yeah, thank you, David. I think for those participants, if you do not know what is the red list, orange list, or the green list, please find out, or you may take certain course and understand that. I think you can resolve for that. So we are come to 10:30. It's about the end of the session. Thank you so much, David. I know there are so many things that we can ask and all these things, but time is constrained and there's so many sessions to be carried out. But thank you so much. I think your presentation is everything. It's been explained so clearly from the beginning and how it's supposed to be conducted and whatever. So that's perfectly been presented, and I believe everyone is quite clear about that. And this is the basic. So hopefully our ADR committees can conduct a real course so that you train more mediators among the architects. Not for all to become the mediator, but at least you know how to own and how to know doing the soft skills in terms of when you do your practices as well. So it's pretty important. So thank you again to our speaker, David, and to all the participants. Again, a general reminder, just now there's a code popping out from the screen. So please screenshot if if you keen a little bit slow, screenshot it. And that is actually for you to lock out. Otherwise, you are not entitled and not eligible to claim for your CPD points later. So again, last but not least, I would like to thank you to our CPD chairs, Architect Abu Zarim, and the crew who work behind the screen. So I'll see you all soon, and stay safe and stay healthy. Bye-bye.
Bye-bye, Alice, and thank you for the opportunity given. And remember, those architects with qualification and mediation, do join us in ADR, yeah?
Yes, we need all of you here to yes. Thank you so much again. Bye-bye, everyone.